Sometimes it's not as simple as asking your neighbors to make less noise. Many Malaysians grapple with the bigger neighborly disputes and daily nuisance such as unreasonable renovation work, open-air burning, and unruly pets. Currently, there is no specific law in Malaysia to address nuisance caused by neighbors. It's high time we enact one. Whenever there is a dispute between neighbors, the legal cost is too expensive to initiate legal proceedings in the court of law. Perhaps the government could establish a quasi-court in the form of a tribunal dispute resolution platform. We hope our lawmakers will enact new laws to tackle problematic, annoying, and difficult neighbors. Now, in this episode, I would like to highlight on a clarion call for a new law to tackle unneighborly neighbors. In this time and age, there's plenty of information, guides, articles, tools, checklists available online that can help you to shop for a perfect dream home. More often than not, you will be advised to conduct the necessary due diligence on the subject property and legal ownership. However, one aspect often neglected is to check on the caliber of those living next door.
Hey, how's it going? Are you our new neighbors? We're your new neighbors!
Yeah.
In some cases, you would not even know who your neighbors are, especially when buying property in the primary market, that is, direct from developers, and only come to suffer later when you find out your neighbors is a real pain. Although no fault of your own, a bad neighbor can make a huge toll on your life. From rowdy, midweek, or wee hours party to dogs that bark incessantly and cat feces at your doorsteps, the excesses of inconsiderate neighbors are among the most annoying aspects in community living.
I called the cops because you were being noisy, man. And I tried to get you to stop, and you wouldn't stop. They won't stop partying.
Legally speaking, the annoyance caused by your neighbors can be classified as nuisance, which is a branched or subset of the big tree of tort of law. After exhausting all available diplomatic means and self-help remedies to counter such hellish neighbors, such as having peaceful talk with them, complaining to the local authorities and lodging police reports, but to no avail, then the last resort would be to take legal action in a court of law.
Two neighbours you're about to meet have become bitter enemies. Their fight has put one behind bars. She's 86 and there's no truce in sight.
However, many will know this is not economically viable in most instances as legal fees are expensive and the process will be time-consuming. To fill this gap, in my humble view, there is a need for legislative intervention from government to address the prevailing social issues of problematic neighbors. We need a law that can, among others, facilitate the resolutions of community disputes in a speedy, inexpensive, and effective way. As we seek to explore some possible features of our proposed new law, it may be instructive for us to refer to our permanent neighbour down south for the Community Dispute Resolution Act 2015 in Singapore, CDRA, as a starting guide. Defining neighbours. By taking the cue from Singapore's CDRA, there are a few salient features that our proposed new law should encompass. For starters, it should only be confined to residential properties. In the Singapore CDRA, the phrase place of residence is used throughout the legislation. It is also instructive to note the word neighbour used in the Singapore CDRA refers to a person who lives in the same building as you or lives within 100 meters radius of your place of residence but does not include a person who lives in the same place of residence as you. Interference nuisance. Generally, in order to establish the tort of nuisance, you must prove that the act or omission of the neighbours have caused unreasonable interference with his or her enjoyment or use of the place of residence. For better illustration, the Singapore CDRA lists down 10 examples of interference by neighbours, not exhaustive though, namely 1. Causing excessive noise, smell, smoke, light or vibration.
Our new neighbour came in about 3 months ago. From then on, my life and my family life actually is in such a tremendous state of panic, anxiety, trauma.
2. Littering at or in the vicinity of place of residence. 3. Obstructing your place of residence. 4. Interfering with your movable properties.
The front yard resembles a rubbish tip.
How about a gutful of this?
I live in this bloody street too.
There's big rats coming through.
Rats.
Yeah.
These residents lash out and threaten anyone
Come and have a look at my f***ing house. Look at that.
who dares ask about the eyesore that is their front yard.
5. Conducting surveillance on you or your place of residence, where the surveillance is done at or in the vicinity of your place of residence. 6. Trespassing on your place of residence. 7. Allowing his or her animals to trespass on your place of residence to cause excessive noise or smell, or to defecate or urinate at the vicinity of your place of residence. 8. Verbally vulgar, abusive, and intimidating nature. 9. Damaging common facilities and properties. And 10. Causing mischief, distress, and annoyance.
Are you being a bully to your neighbours, Rob? What are you doing with the hose? Right. So you're being a big bully to me now as well.
They're wild.
So Rob can bully your neighbours, but he's too scared to come out and talk to us. Excuse me, sir. What are you doing?
Out of control
The neighbours are harassing like this.
and have no shame.
So I have reacted. Get it?
Now, these examples can serve as a guide to shed lights on the prospective complainant when he or she is contemplating filing a claim in the tribunal for the interference caused by his or her neighbour. Now, it is important to note that it is ultimately up to the tribunal to decide whether or not a particular act tantamounts to nuisance or unreasonable interference based on the facts and circumstances of each case. Now, the tribunal being a dispute resolution mechanism. Central to our proposed new law is the establishment of a quasi-court in the form of a tribunal acting as an accessible and efficient platform for individuals to resolve their neighbours' dispute. A special tribunal to expedite the resolutions of neighbours' dispute, as the proceedings are less formal compared to the conventional courts of law and, more importantly, cost-efficient. As with any other tribunals, only the party to the proceedings can present his or her own case without representation by any lawyer, unless otherwise ordered by the tribunal. Now, this special tribunal should be given power to grant orders which could typically be made by the conventional court, such as damages, specific performance, injunction, etc. Perhaps it may be a good idea to direct the parties involved to mandatorily attend mediation before the case is being heard by the judge, as mediation has a high success rate for a dispute of this nature. It is foreseeable that there would be a limit on the mandatory jurisdiction imposed on this special tribunal. In the Singapore CDRA, the maximum monetary order that its tribunal can grant is Sing dollars 20,000. As such, more studies and research need to be carried out in establishing the monetary jurisdiction for this special tribunal. Further, all checklists, prescribed forms and documents necessary for the filing of a claim, as well as clear guidelines, processes, list of registration fees, and frequently asked questions (FAQ) should be made available on a website so as to render it accessible, more user-friendly, and easier understood by the general public. It's high time for such a law. Just like the proposed Residential Tenancy Act, which I have given emphasis in my earlier episode 12, it is high time that our lawmakers should give our proposal serious thought in order to put an end to the woes caused by unneighbourly neighbours. Perhaps the proposed law governing neighbourly behaviours should be merged with the Residential Tenancy Act to make it more complete. However, as with any law's enactment process, we should not just adopt the laws from other countries blindly without taking into account our own social, cultural, economic circumstances. There need to be a robust discussion and in-depth study by the relevant stakeholders before codifying this into a law, and thus turn our neighbourhood into better places to live for our fellow rakyat. There are numerous trivial questions on my laptop screen, but I'll just read aloud a question and a feedback from a reader of my article. Dr. Cheng, you were a counsellor serving at Majlis Perbandaran Subang Jaya previously. You remember the case of dog feces flowing from the neighbouring house every morning when the owner washes his car and selfishly cleans his own driveway? The dog feces flow onto the roads and some of the neighbour's house. You managed to convince the owner to stop the indiscriminate act. How did you do it? It was easy. As a councillor, I had access to all the head of departments in the local council level. I notified the head of a health department and required the head of enforcement department to give notice to the inconsiderate owner. If he refuses to abide by the 14 days notice, the local council will issue summons to him to appear in our municipal court. He immediately ceased all his nonsense. Hope he doesn't repeat such inconsiderate and unneighbourly behaviour. Let me now read an abstract from a reader of my column. Quote, I'm optimistic that if this issue garners more attention from the media and especially lawmakers, we can subsequently have a new set of laws for the community. This issue has plagued our community for long as it shouldn't have, especially those living in high-rise buildings like myself. For instance, let me highlight the nuisance caused by a neighbour who rented a unit right above mine. The noise they make is not only in the daytime but even during midnight. Once the police found them chopping up chicken feet on the floor at 1 a.m., certainly not something anyone would do. To illustrate, this sounded exactly like an ongoing renovation work. We tried to communicate with them amicably, but were met with much hostility. We then addressed our complaint to Management Corporation MC, State Assemblyman Adun, City Council and the police. I was subsequently referred to a City Councillor who then liaised with the City Council's COB, Commissioner of Building. COB stated that it was only empowered to give verbal and written warning to the nuisance creator and instructed the MC to look into the matter. In response, the MC said that they too could only give verbal and written warning. The police were initially reluctant to take report on the matter as they deemed it to be a civil dispute. At this juncture, I felt the need to point out to the police that its men and women in blue should understand that minor offences were still offences. Section 107(4) of the Criminal Procedure Code (CPC) states that a police officer shall be duty-bound to receive any information in relation to any offence committed anywhere in Malaysia. The issue was resolved after a notice of demand by his lawyer was issued to the nuisance creator and the unit owner. In Malaysia, there is no specific law on nuisance caused by neighbours, but there are provisions which could arguably make this an offence. Section 268 of the Penal Code provides for the offence of public nuisance, essentially covering anyone affected in the vicinity. The issue with this provision is that oftentimes other neighbours, although affected, are afraid to lodge police report for fear of retaliation and because they feel they are less affected compared to the immediate dwellers to the nuisance creator. Section 13(1) of the Minor Offences Act 1955 states that it is an offence to make excessive noise between 12 a.m. and 6 a.m. Time and again, I've highlighted this provision to the police, but they have opined otherwise. Although noise nuisance is not specifically provided for under the Local Government Act 1976, Section 81K of the Act empowers the local authorities to declare any matters to be a nuisance. It is my humble opinion that if the lawmakers do not pass a specific law targeting nuisance created by neighbours, the local authority should at least make good use of this provision to declare such to be a nuisance. It is very unfortunate that the civil justice system is not easily accessible by the general public, mainly due to its high cost. Apart from civil action and until the new legislation as proposed is passed based on existing legislation, those who suffer from nuisance created by neighbours from hell,
hellish. Absolutely hellish.
Can lodge a police report and ask for the matter to be investigated for minor offences. If the IO, investigating officer, declares or classifies the case as NFA, no further action, one should insist on his or her right, but please do it politely. Everyone is afforded equal protection under law, but even if there is adequate protection, will there be adequate enforcement? Unquote. Thank you for the excellent question and feedback to the gentleman who wrote to me. My next talk will be titled Choose the Right Leader and Prosper. A good leader can make a lot of difference for community spirit. Selecting a leader with the right strength and qualities can lead to a more productive and happy community in resident association, joint management bodies, JMB, and management council MC in stratified property. See you in the next episode. Cheers.